Okay, welcome everybody. Welcome back. If you're rejoining us, welcome. If this is your first time joining us, we're glad you're here. I think we're going to kind of launch in our discussion tonight. We're going to be reviewing and talking about advance directives, advanced planning, including financial and medical, and all of the kind of the nuts and bolts that are important housekeeping items as we talk about planning for the end of life. So I think tonight is going to be a little less emotional. We've had some pretty intense conversations over the last several months. Tonight is really exciting. I think they're very genuine, actionable items and things that I think we can all walk away with tonight and put into action. So that'd be great. Ryan's going to kind of take the bulk of this because this is his world. So I think we'll just kind of launch right into it.
Sounds great.
We'll just kind of start off with a broad question about what are advance directives.
So advance directives, think of them as directives while you're living that you want to have there for end of life, or if you're incapacitated. So examples of those would be a financial power of attorney. So a power of attorney is you're putting in writing a succession of who you would want to actually make decisions for all things financial. Those powers are typically listed out as well. So items like if you want them to be able to transact property or sign a lease, things of walk the dog, sign a tax return if you're unable to, making those decisions about financial matters. You can also have a separate healthcare power of attorney. So a healthcare power of attorney would be more in line with somebody who would make those decisions around your health if you're unable to, if you're, taking the information from a physician or the hospital and making those decisions when you're not able to make those decisions on your behalf the way that you would want those to happen. And then there's living will as well. So a living will is an advance directive that oftentimes gets talked about. That's sometimes incorporated alongside the power of attorney, which would basically state your wishes in writing in terms of what you're actually wanting to have happen. If you don't want to extend life when you have an emergency or something that happens, that living will would put that in writing to make that easier on the agent to make that decision along with the medical professionals to do that. Sometimes the healthcare power and financial powers of attorney are combined into one power of attorney, but oftentimes you can have different people play different roles. I always give the example of somebody might be more suited or closer to you in proximity. If they live in your city, it's going to be a lot easier for that child or that person, relative or trusted family member, to come over and check the mail, check on you, do those things. Somebody that may be medically trained, maybe a person in your family is a nurse or they have medical training and you'd like them to be responsible for triaging some of those decisions on medical purposes, that oftentimes can be the case. So those key documents you want to have in place as an advance directive, so you're deciding who's making those decisions and putting that in writing.
Good. So we're talking medical documents, we're talking financial documents. Are these things that you can complete on your own online? Are there simple forms? Is it somebody that we probably should be using a professional to go through that process? What does that look like kind of in all of our options?
So the overwhelming majority of those forms are being completed by a licensed attorney. You can go and consult with a specialist. There's so many variables in local jurisdictions, the county you live in, the state that you live in, those types of things. There are some online tools, LegalZoom, the different places where you can go out and actually put a template in and draft it. But more often than not, this is something you want to get really right, and going to professional makes the most sense.
And if we're searching out a professional, is this a specialty, or is this would this be from let's talk from a lawyer perspective? Is this a general practice issue, or is this somebody you'd want to search out somebody who spends their days doing these documents?
It's a specialty that you want to look for, and typically that's an estate planning attorney or somebody who specializes in elder care could even do something like that. But Usually it's especially in estate planning, not as much litigation or something of that matter. So usually those practices are pretty concentrated in estate planning.
Good. That's a great overview of this broad term of advanced directives. We'll dive into some of the bits and pieces
more practical,
right, as we go through this. But I think another overarching question is we kind of got an idea of what we're talking about, what these documents are. Who should be pursuing completion of these?
So it really should be everybody that's an adult. So, I'm a father of a 13-year-old and going to be a 10-year-old. When they turn 18, we're going to sit down and they're going to have basic core documents. So core document meaning a financial power of attorney, a healthcare power of attorney, and even just a basic will, from that perspective.
Yep.
And we'll talk more about wills later in end-of-life planning, but it's very important to state who you would want making critical decisions if you were unable to, because that can come upon us in a planned manner where we have time to plan for that, and sometimes it can come abruptly.
Yep.
So it makes sense to have that. If you're an adult, if you're above the age of majority in your state, it'd be great because you're making your own decisions at that point. You want to have a backup if you're unable to.
Good. So certainly people who are in a position of having to think about or plan for the end of life, but really everybody.
That's right.
Everybody who's a age of majority should be having some documents. From an application standpoint, from somebody who's taking those documents and trying to put them into practice in the medical world, they truly are gifts to those who you're leaving behind, or those who are now in charge with surrogate decision making, or any of those, because what I've seen is it takes a lot of the decisions or right, you need to serve as somebody's surrogate decision maker, right? Your goal is to advocate for them and carry out their wishes. And if those wishes are known and, more importantly, put on paper, it just it seems like a much easier, gentler, more appropriate path. And I say it's a gift because I've seen families who are in a position without those documents. And there's a lot of consternation associated with that. So
Yes.
I like that message. Everybody, right? Everybody should have Advance Directives. So this next question, right, I think it tails into that. Who should have a power of attorney, a medical power of attorney, and maybe compare and contrast that to guardianship and maybe a fiduciary is a term, or a financial power of attorney, and kind of what those documents look like. Yeah.
So a financial power of attorney, as we look at that a little bit deeper, you're having specific powers that you're giving your authorization toward. And there's some things that you may not want to change. If you don't want the house to be sold, then maybe that's a power you don't add into that until you're gone, while you're living. So you can make those specialty decisions. Any person that is an agent, so the term agent would just mean that that's the person in power of attorney that would be that person making the decision if you're not able to. And it's usually a good idea to have a backup or two, a backup agent. If somebody can't get there, sometimes there's multiple children, sometimes there's multiple family members or professionals that you want to put in there to serve as that capacity. In any of the documents that we talk about, financial power of attorney or healthcare power of attorney, when you're serving as an agent in that capacity, you are a fiduciary. In other words, you're carrying out what you would feel would be the best wishes to your best ability, above all else, of that person you're serving for. So it becomes a really important role to have a trusted friend or family member in that condition. A medical power of attorney a lot of people will like to have separate documents because the person that may be best equipped to do that for medical, you wouldn't want near your finances. Right. And I can speak to that, in some cases, and vice versa. And so it's important to have those pieces in place. Any person that has minor children should consider guardianship. So guardianship would be a portion of your will or a document that would state, if I'm unable to be around to care for my young ones, these are who would be the guardians. And so oftentimes those people are the same, from a financial perspective, so they're able to access and not be financially burdened while they're taking care of your young children. But sometimes they're different as a check and balance. Sometimes people will put a guardian as somebody who maybe lines up with how they would have raised their kids or their ideals. Or so think about, if you have older parents in their 70s or 80s, and maybe the guardian might not, intuitively it might be them, but it may be somebody who's more in line with getting them signed up for soccer and making sure that they go and follow the things that you care about, and that's all important to consider with guardianship. But if you have minor children, a guardian's going to be somebody that you're going to think about.
So putting guardianship is in place for when you're talking minors, for who's going to take on that responsibility. Right. something that hopefully we all encounter a little less is guardianship over an adult.
Right.
Kind of a different set of circumstances, different application.
Yeah.
Maybe we could touch on that just a little bit. I'll just tell you from an application standpoint, I see guardianship most often in situations where nobody made any other plans.
Yeah.
And it's a court situation, and the judge has to get involved, and it's not a short or easy process.
Right.
You may not even deal with that very much. I mean, ideally, if we're planning ahead of time, guardianship is avoided altogether. But
We see it a lot, and in terms of, when I say a lot, every time we see it, it's usually a court involvement. So if you're thinking about it and you know of people that you can write in to be a guardian if you for some reason would need that, it streamlines it a lot faster to make sure things are not disrupted, to your point.
Good.
Yeah.
Okay.
Absolutely.
you brought up something just in the last little bit that I run into, and I thought it's an important distinction just to talk about. You can have, at least from a medical power of attorney, you can have dual or joint surrogate decision-making power, or you can have primary and secondary, or primary and alternate. Right? Those behave differently. At least when I'm trying to put those into action. I like the primary and secondary because we know who to go to, and if that person's unavailable or chooses not to, whatever the case may be, we have the next person. The joints have it sets up a situation where it can get a little tricky because we're legally have to wait for a consensus for those two people.
Right.
And if there's disagreement, we're stuck.
Yep.
Right? So you are probably often setting up or encouraging alternate first and secondary. Is that common?
So we see it all, and I'm obviously not an attorney, but our firm practices, creative planning practices law. When you look at, you can see joint and you can see succession, where there's a first and then a second and a
Yep.
third. Typically having somebody be a point person tends to work a lot better, a lot faster. Sometimes you'll see people with multiple be unanimous. So sometimes you'll have three altogether joint, and you'll see they have to be unanimous, which, as you can imagine, can get a little bit more cumbersome.
Yeah.
It puts more of a burden on them. Philosophy to that is, hey, I want them all around and talking. So some people are intentional. If I'm not able to, my kids are going to have to figure it out together. That's what I want. But when the rubber hits the road, to your point, sometimes it's a better fit to have that dedicated person that has maybe proximity as a factor, maybe age is a factor, maturity is a factor,
Yep. Good.
And then you move on to the secondary and third option if it's needed.
Excellent. So we've made these documents, living wills, power of attorneys. What do we do with those documents? Do they need to be filed with the state? Do they need to be stored in some repository that somebody can search? Or do we keep them at home and give them to who we think needs to have them?
So oftentimes there's this perception that it has to be filed with the state. It doesn't. You actually would keep those documents in your possession. A lot of people will put them in a safety deposit box. We typically recommend that you hold them close to you. So our clients all have a binder, and that binder we'll get to more of the financial piece, but it would consolidate things like deeds, titles, passports, social security cards, important documents like that, and original executed estate planning documents. So those are typically notarized and what you would call the wet ink document.
Yep.
In your possession. Sometimes the bank's not conveniently open when you have an incapacity event, right, on Sunday or a holiday or things like that, or you don't have all-time access
Sure.
to your safety deposit box. So it's important to have that. We also recommend that you scan it and you have an electronic file, encrypted, electronic file that you have maybe on the cloud or something, and providing that information to the agent that you would have as well, so they can access that electronically if needed. It's a good practice to, if you go to a primary physician or you have that they have a copy of that
Absolutely.
most updated document. And we'll talk more about what if that isn't the case,
Yep.
and 911 and all
Yep.
that. But it's very important. That's really, you need to know where yours are at, and your agent needs to know, if you're not around, where to find it. And then your physician and where you frequent from a hospital or network perspective needs to have a copy.
So if somebody's passed or incapacitated, can't make their own decision, we're in need of these documents, and nobody's aware of where they are or that they exist, is there a way to, I would relate it kind of similar to like a life insurance policy, right? I know that you can dig and sometimes find those. These documents, that's probably not necessarily true because they don't live in a state repository or anything.
That's right.
So copies, send them to anybody you trust and would want access to. Okay,
Yep.
good.
Yep.
So are there particular laws to be aware of? I think, let's say, in really specifically Iowa to Nebraska, right? Because we live so close that we're often crossing borders. And are there laws that people need to be aware of as far as crossing borders, or if we're in Western Iowa, is there something different that we need to be doing than in Eastern Nebraska?
So you have some examples of where this comes into play,
Yep.
Which I'd love for you to share. But if you look at two states, some things that are uncommonly known is there is an inheritance tax. So Nebraska does have an inheritance tax in place. Iowa has an inheritance tax for what you would consider non-close relatives. So I'll explain that a little bit. So Nebraska, if you have close relatives, which would be considered lineal descendants, grandparents, siblings, parents, close relatives, all of the assets when you're gone in Nebraska would have an inheritance tax, and that's 1% of your overall net worth. So that's something that has to be done after you're gone, which is unique to Nebraska. There's not many states that still have that. If you leave the assets to non-close relatives, so think about like an aunt and uncle, niece and nephew, somebody like that, the rate goes up to 13%. So it's pretty significant. So it's exempt by $40,000 per beneficiary. So let's say that you had an estate and you were going to leave a certain amount. $40,000 to each of those beneficiaries would be exempt from any inheritance tax, and then anything over that would be 1% or 13% under how it's currently structured. So that can be pretty significant. And when we get into the financial planning part, some things people think about when they have a life-ending or a threatening illness is when the year turns over in January, they do all their gifting right away. So you can gift up to $16,000 a year, free of federal estate taxes as a gift in cash. If you make those gifts, obviously, if you don't die with that capital, it can't be taxed at a state
Sure.
level or a jurisdiction level. So one of the financial planning pieces is, obviously, if you have enough capital and you're trying to move assets, they're going to get them anyway. It's a good exercise. And sometimes even if you're a power of attorney acting on behalf of somebody who's incapacitated that would have wanted to do those gifts, those are some powers that can be in there to take advantage of that ahead of time. So thinking about those items are important. Iowa, uniquely enough, has an inheritance tax, but in May of 2021, the legislature met and decided to abolish it over 5 years. So in 2025, it'll be completely gone. It's 20% a year it's reducing.
Sure.
And then in 2025, it goes away.
Okay.
But that's only for non-close relatives. Close relatives are exempt in Iowa. So
Regardless.
Yep.
Okay.
So there are
dollar
some
threshold
unique,
or
right.
Okay.
There's some unique laws, and then but specifically to Advance Directives, I know you had a story that was
and real
unique
quick just to follow up, the laws you're speaking of are applicable to the state that you are a resident of, right? Not necessarily because you died in Iowa, but it's where your residence is, right? Those are the laws that you're governed by.
That's right. That's correct.
So right, my example, it really, let's talk about this next question, and then I think that kind of launches us into that. But what happens if there's no documentation on end-of-life wishes and or no will? And let me take that a step further to say no power of attorney, medical or financial. And I think we can obviously take those, and they mean different things. And let's leave the medical piece to last. So what happens if there is no financial advance directives that anybody can access?
So typically the court would get involved to appoint a conservator or somebody that would be charged with taking care at that point.
And that's after death, right?
So this would be without power of attorney. So that's a good distinction. So powers of attorney are only applicable while you're living.
Okay.
So if you're incapacitated, at death, powers of attorney cease to have merit. So the powers of attorney for financial and healthcare are, well, you're alive, but you're unable to make decisions. So if you haven't made those directives, then typically there's some court involvement to appoint who would make those decisions. There'd be a appointed document. They'd take that to the financial institution or whoever it may be at that point.
So there's avenues.
Right.
They're cumbersome.
They are.
Right.
It's not ideal.
Right. Yeah. And in time of
Yeah.
crisis, emotional or medical or whatever, those things don't happen quickly. And
Right.
so, right, planning is a
huge.
great tool. So what would happen if we had no medical power of attorney? And now we've landed in the hospital and you're on a ventilator. You're in some situation where you cannot speak for yourself or make your own wishes, and you've not put anybody on paper to be a surrogate decision maker. What does that situation look like?
It's a lot more cumbersome. Yeah, you could speak specific. You see that.
Yep.
You've seen that over time.
Yep.
Yeah.
I haven't read the laws in a long time, but unless they've changed, what happens in the medical world is you end up in a situation where we need to look for a surrogate decision maker for whatever reason. If there is no documentation, the state, fortunately, has given us a hierarchy. If I misspeak, please correct me. But
Yeah.
in Nebraska, we would first look to married spouses. If they don't exist or they're not willing to participate, we then look to adult children. If that's not an option, we look to living parents. If that's not an option, we go to children. And in Nebraska, I believe it's a consensual group. The state, when I've read the laws, the state does not give us any guidance. One state I practice in would say the oldest child is the decision maker. Nebraska doesn't give us that guidance. It's a consensual group. I believe those laws are the same. That hierarchy is the same in Iowa. Are you aware?
That's my understanding.
Okay.
Yeah.
And so there are things put in place. They're not. It never works like you'd want it to work.
Right.
But so yes, I think sometimes the assumption is if I don't have those things in place, the state or the hospital or the doctor is going to make those decisions, and that's absolutely not the case. But and that list will go all the way down. You get down into cousin. You get down to extended family. If there's no extended family, the state says a close friend, or is there anybody that wants to step up at this point? In the rare cases where there is nobody, that's where you got to pursue a state guardianship, right? The court designation of somebody to be a decision maker for you. So,
Could take a long time.
yeah, and the point to that story is that there is a resolution if you don't have, excuse me, if you don't have paperwork in place. But if we're talking about really making sure that your goals and wishes are heard and carried out, the best way to achieve that is to plan ahead. Appoint surrogate decision makers, try to have conversations and discussions and documentation as much as you can about what your goals and wishes are. But we do have lots of people who find themselves in a place without those documents, and we work through it. But the ideal world is to pursue exactly what we're talking about here. So. Again, we're kind of talking laws, and neither you or I think we would both say we're not necessarily the resource for the current law, but what laws or ideas govern same-sex couples? I think tonight we can kind of limit that, obviously, to Nebraska and Iowa and what that looks like. And I do have a story about this too, which are real life examples.
So think of it in where we're at, that basically it's from a legal standpoint, it's married or unmarried. You know what I mean? In terms of how assets would be distributed if you don't indicate that. One of the documents that's not necessarily an advance directive, but it's something that's very important that we'll talk about, is a will. And a will is where you would actually state your intention, in terms of where you want your money to go and things, what you want to have done when you're gone, who would play those roles, an executor. Another example, if you don't put things in writing or have that official piece in place, it's left to ambiguity and interpretation, and that can also involve family members and other pieces of the pie that you really didn't envision happening. And so when it comes to that piece, think of it like if you haven't had that plan thoroughly accounted for in your will or your directives to name those parties, they would, in Nebraska, in this area, would look at as from a legal perspective, married or unmarried.
So my story kind of dealt with common law marriage, right?
Yeah.
And my understanding is Iowa recognizes common law.
Yep.
And I don't know what it requires to get there, but essentially you've been partners, you've been life partners, you've been living together for some period of time. The state then, whatever that threshold is, now you're recognized as a married couple. That's my understanding. Am I misspeaking on that?
No, not that I know of.
The problem I ran into is that Nebraska does not recognize common law. So, as a quick example, I had a patient, a same-sex couple in Iowa. She got sick. She went to the hospital. She needed something that wasn't provided in that hospital and got transferred to Omaha. In Iowa, her significant other, unmarried but common law recognized in Iowa, was able to make decisions, was able to be the surrogate decision maker, right? And then went on Tuesday she's in Iowa, Wednesday she's in Nebraska, and this woman has, since that's not recognized here, the common law, that woman had no legal right to be a surrogate decision maker. There was no paperwork that told us what to do. At that point, we were following the state hierarchy.
Interesting.
So what happened here is we watched a woman who was not able to advocate for her significant other of 30 years, and instead had to find siblings who lived in western Nebraska who hadn't seen their sister in over 10 years, and legally had to look to that group for medical decisions, and it was a horribly sad situation. But it was a pretty vivid example of what happens when we don't put things on paper and plan.
Yep.
And so
Underscores the importance of having the documents.
I've seen it once, and it once was enough, because it was a heartbreaking situation where obviously the right answer is this woman should be making decisions for her significant other, and we weren't able to do that. So I just bring that example up as an outlier, but certainly a valid reason of making sure that things are put down on paper and done correctly. So, what governs in 9/11 treatment emergencies, advance directives or state laws?
So if you had made your way into the hospital that had the documents on file, then the documents would govern that. So if you had a healthcare power of attorney and everybody knew what those wishes were and they were on file, then they're going to go by the document. If it's an emergency and you end up out of network somewhere, they're going to just try to sustain your life. That's the general rule. They're going to try to keep you alive at all costs until people arrive that have that power.
Yeah, and I would say the medical default is, like you said, do everything.
Yep.
Even if it's against your wishes, because at that point in time, there's no way to know what your wishes are, and so the assumption is we're going to do everything, and so that's the only kind of situation I can think of. I'm not even sure where else state laws come into play. But the state is they view autonomous decision making as a very important thing. So taking that away or losing that right is something the state is not interested in doing. So documentation again kind of guides us, brings us in.
One of the pieces that related to that we talk a little bit about is if you have older documents, it's important to look at those documents at a pretty frequent clip. The HIPAA, who is basically, it's the Health Insurance Portability and
Privacy and Portability Act.
Privacy and Portability Act, was passed in 1996, and that gives some authority for those people that are making decisions to gain the best access to the information, from a privacy perspective.
Sure.
So you could run into a scenario where you have appointed somebody through your power of attorney document, but you didn't have a HIPAA language in the document that would allow them to maybe get all the information that they wanted. So it's important to consult with an attorney or somebody that's a specialist to look at that to say, hey, do I have everything I need?
You're talking
Make sure-
like lots of times documents that are pre-1996.
Yeah, older
right?
documents, right? Yeah.
And HIPAA maybe has even, I mean, in practice, it's certainly changed since 1996.
That's right.
I don't know if by the letter of the law, if things have changed, but
Yeah. So sometimes with the power of attorney for medical, there'll be an accompanying HIPAA authorization that you've notarized on top of that to say, hey, they can make decisions for me, but also if you have any information to share that would help them in that decision, basically have at it, you know.
So I think to that, it's important when you give your documents out to people to remember who you gave them to, because all those documents, when I read them and try to put them into practice, they all say that if there's a superseding document, that's the one that's in force. But if you don't know it exists,
Yeah.
the one from 1992 is the only one we have. So
That's
anytime your wishes change, your goals change, any of that changes, make sure you update your documents. You said something earlier that was great. Just take the old one and shred it, right?
Yep.
I keep things around, but you're
all
only
do.
complicating the situation keeping those documents that are.
We all have some things that we have loss aversion around,
Right.
you know, whether it's that shirt that really doesn't fit you good, but you're never going to get rid of it because it costs you too much or whatever.
Right.
Legal is one of those deals where you paid for all these, and if you're like anybody else, like, here's the folder for all my legal stuff, and I'm putting it in there. When you're piling it on and you change it, you know, if you update your will or you update any of these documents, what you don't want is confusion. You don't want somebody to say, well, here's one, and putting together which replaces which. So when you have that executed at that time, I'd ask your attorney if these are good to shred and get them out of
That's a great point.
the area for storage, so there's no question what the governing documents are and what's helping you along the way.
These next couple of questions, I think that we have covered philosophically in prior talks, but I'd be interested from your perspective, from kind of putting pen to paper, who needs an end-of-life plan? And maybe, you know, similarly, what types of things should that include? Or at least when people are coming to you to help with that, you know, what does that look like? What is that conversation like?
So almost everybody needs an end-of-life plan because that's one thing we all have in common, right? We're all going to be gone at some point. So some of the key items to really have in place are an organization of your information. So what we do a lot of is try to organize at least once a year, update your statement of financial position. So a rough outline of what do you have in terms of where do you bank, even if you think it's inconsequential. Well, I had that account because they gave me a rate on a car one time and I never closed it.
Sure.
Well, somebody has to go find that account and close it when you're gone, right? So anything that you put in place and then just update that once a year. With that, it's important to have updated documents for what we've talked about, Advance Directives, you know, we'll get into some of those documents a little bit later. All of that consolidated as well. And then some things to think about are really where is a consolidated place for passwords, you know? So if we have significant other or somebody that really needs to go find information, it's really good to have a notation or some password legend, if you will, to help them get that in place. And then, you know, it could be as simple as even starting to simplify, right? So having so many bank accounts, you know, trying to get that down to a more consolidated place so that information is readily available. It's easy to get to. You're not burdening anybody with those matters when you're
Sure.
gone. And it's really healthy too to just look at that every year when you're trying to track toward other goals, you know, whether it's retirement or you're trying to buy another home or you want to remodel the bathroom or whatever it is. You know, it's part of that. I'd make it just part of that annual process where you're actually looking at that and saying, well, geez, you know, a great example is we went through the pandemic in 2020 and a lot of laws came out of that. So the fall before that, the Secure Act came out, and then during the pandemic, it generated the CARES Act. Well, all of that implicated in some way your retirement plan or the documents that you have. When those events happen, it's a good time to check in with your attorney and
Sure.
say, hey, here's what happened. Do I need to do anything? Is there anything that's fundamentally changed with me? And those are just good pieces to have in place. So I'd say, you know, have all the documents that are updated in place, organize your information, try to simplify passwords, and then have a process where you're checking in, you know, at least annually for that.
Yep, good. And I think I know the answer is the same as my answer. I can almost guarantee it's the same as every panelist and guest we've had up here, but who should have an end-of-life plan? Everybody.
Everybody.
Right?
Yeah.
Doesn't matter necessarily where you're at in that process, and that plan might look different when you're 25 or 45 than when you're 75. But
Yep. And it changes as you evolve with family and
what your
young
needs
children
are,
versus
right.
adult children, and absolutely.
We've got 2 questions. I think we've probably addressed this, but who needs to have possession of documents regarding my end-of-life plans? Well, I mean, as many people as you trust and can think about that might be able to need access or produce that access, I think.
So notifying who you've designated as agents, making sure they're comfortable with that, and then knowing where they find those documents. Sometimes people will keep the originals, and then they'll provide a copy via, encrypted link or something like that of the power. Here's where I indicated you. Here's what I want, and really where to find that information. Sometimes if you have, children that are young adults or something like that, you maybe don't want to show them, here's my financial statement, here's what I have, right? There's some pieces with that. So just giving them access to, here's where the binder is, it's in the safe, we have everything there if something happens, that kind of thing. So it's really the people that are going to play roles need to be notified ahead of time and give them a copy if you can. But the originals should always stay with you. You should know where those originals are. I've run into cases before where people said, oh, that's at my attorney's office, and something happens, and you call the attorney's office, or not even an attorney, just wherever the office is, and there's somebody out east of a client of ours who the attorney wasn't in business anymore, and then another one it was in their cave, and so they took 2 days to go to the cave and get the documents out. So I think just having control and knowing where your documents are is a really important thing.
Yeah, you said something that I think I actually encountered just the other day. It is very important to involve the people that you're designating as your surrogate decision maker, have your power of attorney, that you're making that move, right? Yeah. I mean, I had one the other day where medical power of attorney stated this person, we contact that person, they had no knowledge that they had been put in that role. And they're not legally obligated to serve that. You can recuse yourself. Even if you are listed as power of attorney, you can always recuse yourself. And if that's the case, then we go to that state hierarchy that we talked about. But it was an interesting situation that I thought you went through the process of making this document, not as involved as I think you would have liked to have seen, but it was something on paper. It gave us a point of contact, but they didn't close the loop and actually involve that person in the decision. So, we're kind of back to square one. So it seems like an obvious point, but it's an excellent point. Make sure that person is agreeing to serve the role that you're asking them to be in. So
That's right.
that kind of sums up, wraps up our kind of first section on advanced directives. I think it's an excellent time to take some questions from people online. So let's see, these are going to be things we haven't covered, so let's dig in here. So how do we determine who is best to determine our end-of-life issues? How do I determine which of my 3 adult children to assign those duties to? I think we both have to. I'll give that to you first to see how you'd answer that.
Yeah, so there's no definite answer to this, and everybody has a good feel for the strengths of their family members and who they want to serve in those roles. But I can tell you there's a few things that make it more objective. Sometimes it's age, so sometimes the oldest is a default, for a lot of these roles, but sometimes we know deep down the middle one's the one that has the expertise or whatever. And so sometimes it's a conversation around what did you go to school for, or what do you have interest in, or what's down your more natural path. And having that conversation when you make that decision, because sometimes if you make that decision and it's not what would be intuitive to, or what they think it might be,
sure,
that surprise can be painful at the end, and you're not around to really talk about it. So I would say don't be fearful to have that conversation. So that's one. The second might be proximity. If somebody's closer and one of your children live in Seattle and it's harder to get to Omaha, that definitely plays a role with, if taking you to a doctor appointment or being involved with those kind of things, or going over and checking on your house when you're not able to. That's a pretty common decision-making processes in regards to proximity. So it's a lot of times it's about engagement, specialty, and maturity, and then it's proximity that go into those decisions. And a lot of people, it gets emotional. You don't want to hurt somebody's feelings, or you're trying to think how they'll respond. I would just encourage you to have the conversation. Just say, hey, when something happens to us at some point, here's what we were thinking. What are your thoughts, and engage that process.
Yeah, I would agree. I don't know how necessary. I think how you determine that has got to be unique to your situation and the people that you're bringing into your circle. The issue between 3 adult children, I really think the solution to that, like you said, Ryan, is an open, honest conversation. The end of life and death and all the emotion that comes with that, like it brings a lot of skeletons out of the closets, and we all have them. This one comes up a lot, where I had a situation recently where one of the adult children was named as the power of attorney. The other 2 did not know that one was, but it came out when we had to enact power of attorney, and boom, all of a sudden the attention got diverted from where it really needed to be, which was on the person who's going through this. And it was all of this wrangling of the psychosocial aspect of that decision. So I think a lot of it, like you said, comes out as we're having honest, open conversations. But I think what I have seen is you have to have somebody that you can trust is going to advocate for your best interests when you're no longer able to. And ideally somebody that you've had real conversations with, right? Don't just throw them a power of attorney paperwork and say, you're it. I think that person really needs to have insight into what choices you would want made for yourself. And so it's difficult. I would argue less difficult than leaving it up to chance, right?
Yes.
Saying, I can't figure it out, I'm not going to do the document, because then what happens is you have real fighting. Right. And then the state laws do dictate, and it becomes a messy situation. So I always say, leave your family the gift of preparation, because it takes a lot of that guilt and burden off of their shoulders. And
you see it a lot with guardian. Who do we leave if we, it's an improbable event, but if you're both gone, who watches your kids? And you see that inertia, and sometimes that inertia for one decision will prevent you from implementing the other decisions. And I would say try to get something down, and then you can always come back and make those changes.
Sure. Good. Good. Let's see. We got a few more questions submitted. This is an excellent question. What is the basic cost for advance directives prepared by a professional? And then as a subset to that, do hospitals and social workers help with these documents if the funds are not available, meaning someone can't afford to hire a professional? What does that situation look like?
So advance directives for financial and healthcare powers of attorney probably range, $300 to $500, depending on what types of, complexity is going to be in the document. If you look at, a basic will, you might be in the $700 to $1,000 range. And then we'll talk more about trusts later, in that $2,000 to $3,000 range. And all of this is going to be dependent upon the various things that are happening and property that you own and things like that. But generally, it's not as overwhelming as you might think, to get those documents in place. And if you didn't have any, actually when you go to the hospital before you have a major procedure, they usually have a template of a power of attorney that they give you. And so that at a minimum would be an indication. You can also consider, writing and notarizing your own document in terms of who you would want to make decisions if something's pressed or if there's time like that. But generally, it's not as overwhelming as you might think, to get those documents in place.
Are there any financial assistance programs available? Talk about outside the hospital, pre-acute episode. But if those resources don't exist, are there any avenues that we have available?
You could check with a legal team. There might be some outlets to groups or affiliations that volunteer for pro bono or work like that. I'm not familiar with a particular organization that does that, but I know it. We'll talk more about resources. But if you went to there's services for like bereavement for children. There's like places where they can go and they can find groups and other associations to fit that. But usually it's going to be a law firm or a specialty group that provides some of those services.
Good.
That could be available.
And we're going to dig into this a little bit more shortly here, but just talking about the cost, some of those, I mean, that could be daunting. I'm sure you would argue too that that's a fairly small dollar amount for the value that you're getting out of that, right? For what the protection that comes from that. But be that as it may, it's a difficult situation for lots of people. But one thing I didn't know until we were talking earlier, that there is a cost associated with not having a plan.
That's right.
When you go through probate and what that looks like, and so
Significant.
there's a cost analysis that you and I were talking about earlier that makes this dollar amount for preparing your documents seem like a much better
Nominal
way to go.
Right. Yeah. One piece that's related to this is that advance directives are agents to make decisions. One thing that a lot of people don't understand, and we'll talk more about that, is a will is what you have in place to tell what your wishes are. But you can direct beneficiary accounts. So, if it's a bank account, checking account, brokerage account, your IRA, you can, in our state, you can put a beneficiary on those, and that would bypass any court involvement. So just to make sure your assets get to where they go, and you have some advanced directives for financial and healthcare powers of attorney, can be very low cost to just have your basis covered, and can go a long way.
So that you're saying that you can show up at the bank with that person, and
you don't even need the person. You can show up at the bank and say, I have an account, I want to add a beneficiary to it. Can you give me the form? And that form at a bank may be called a payable on death form, as an example. And you fill it out, you put their name, their relationship to you, social security number. That's going to go directly to them if you're gone. Now, not if you're incapacitated. That's why it's so important to have.
So it doesn't give that person access to pay your bills
They're
while
not
you're
a signer.
still alive.
They can't do those things.
Okay.
But yeah.
So this question says, I need help finding someone that can accommodate both Iowa and Nebraska. If I go into hospice care, it would likely be by my family in Iowa. I get my care and live in Nebraska now. What do I need to do to be covered as a resident in both states?
I don't know. You might know that one better than I.
Yeah. That's a great question.
Yeah.
I think I just want to make sure, I'm speaking from my experience, not that I know the law or any of that, and it's not, I don't want to misspeak. I have not, in 15 years of doing this work, I have not come across an issue where this question has ever even been an issue or a concern. So, not to cast that off, I just haven't encountered it. The most prominent example I can think of is the one that we talked about earlier with the same-sex couple and common law differences state to state. I might leave that question to see if that person wants to clarify or refine that a little bit, or is there a specific issue that's kind of come up or that you're thinking about. I would say, just from a hospice perspective, hospice will follow you wherever you're at.
That's right.
If you're at home and you got to go to a nursing home, hospice follows you. If you're at home in Omaha and you're going to move to your family in Iowa, hospice can follow you. If the organization has the license to practice in the county that you're moving to, that organization can follow you. They can pass you off to another one of their branches. If there isn't that current hospice organization in your new location, that team will find you a new service. And so that transition is very smooth. I've done it many times going across the country. I've gotten people out of the country. I've never been inhibited or even had to kind of think about the legal issues associated with that. I don't know if you've come across anything in your practice.
I've not. No.
Good. Okay.
I think that's.
Got one more question here before we move on. When preparing to meet with an attorney for power of attorney paperwork, living will, and advance directives, what do we need to prepare and bring with us? Paperwork, contact information for designees, any of those types of things?
That's a great question. So most of the law firms that you'll engage have a worksheet that they can email you ahead. I know we do, and maybe if we have tools or something like that, I can add that up to the site.
That'd be great.
So usually what you're doing is you're taking each of those documents and you're making a 1, 2, 3, who would play those roles, and you're writing them down. So when you go into the meeting, you're not having to think about that, and you're not wasting, if attorneys pay by the hour, you're not wasting a lot of billable hours while you're trying to think about what you want to put in the document. So a worksheet is usually really good, where you'd say, okay, for my healthcare power, this is who I'd like first. If they're not available, this is who I'd want second, and so on. And you do the same for the financial power of attorney. Usually you want their address, any identifying information, contact phone number, email, and then you don't have to have their social security numbers for those type of roles. That's a pretty personal thing to bring, but that's really important to have contact information, the full name of that party, that they can be identified, and their last known address is a good option to have.
Yeah, so think about who you want to be your decision maker for medical, financial, accounts, websites, that type of stuff.
Who you'd want to, distribute any assets that you have at the end to work to, distribute that, or they call that an executor, or a personal representative who's going to carry out those tasks. And even if you go into a trust, which we'll talk in the next segment, a successor trustee, who that would be.
Sure.
Those are the main roles.
Good. Well, that's a great that's a great segue into our next section, which is really going to focus a little bit more heavily on the financial piece. We've talked over the last several sessions lots and lots about medical power of attorney and those wishes and how to accomplish that, but the financial piece it hasn't been a part of our discussion, so this is going to be great. So let's just we'll start at a high level. Kind of umbrella view first, and what's the difference between wills, living wills, trusts, estate plans, any other documents that you're commonly dealing with?
So your core estate plan would typically include documents that tell someone directly what you want done when you're gone, documents that would indicate agents for acting on your behalf if you're not able to while you're alive, and then wishes on how you want that care in terms of life-sustaining measures. So we'll start with the will. So the will comes into effect when you're gone. So not while you're alive, when you're gone. A will is you putting your wishes in writing on where you want your property to go. This can be property like investments or your house, or it can be, you can even state tangible property, like the wedding ring goes to Sally and the Victrola goes to this person, etc. Whatever it may be, you can make those designations. So the will is typically stating on who you would want to actually carry out everything as well. So that's called an executor. And then there's a personal representative, which oftentimes is the same person to fit that. So the will's good because you're directing where it goes, and anything that you forget to put a beneficiary on or you title will go eventually through that will. So the will is good because it tells what you want done, but there's still a court proceeding. That's called probate. So if you pass away and you don't have a property that has a direct beneficiary, and you actually don't leave any beneficiary on certain property, it was just in your name, that will go to a court called probate, and they will read the will, and the judge will actually then formally appoint who you wrote in your document, typically. So that's an executor, whoever it may be. So that's really the function of the will. A revocable trust means while you're living. So it's a living trust. Sometimes it's referred to, or inter vivos, which is Latin for while living. All those mean that it's a revocable trust. So a trust, actually think of that like a building or a shed, and you build this building, and it can be whatever color you want. It can be a garage door at any size that you want, and all these have different doors and windows, but you're building this building. That's the trust, and then you put everything in it once it's built. So your bank accounts, your car, your house, all of your property would be owned by the trust. If you own a business or you have an interest in a partnership, that would be assigned to your trust. So the trust, ultimately, if you're doing it, what you would sign up to do, or what the attorney would help you with, is everything would be in that trust, so you don't personally own anything. So the trust is revocable, meaning you can change it any time, and it goes between states. So if you own a farm in Iowa and you own a house in Nebraska and you have a vacation place in Arizona, you don't have to do probate in Arizona to get that asset settled, probate in Iowa to get the farm settled, and probate in Nebraska to get that settled. The trust would be portable to those areas. So the trust owns that. So the trust is popular because it avoids the court altogether. It keeps things private. So one thing about the probate process is it's a public record. It's a hearing. So that information is going to be known to many. People can show up to that. People can come out of the woodwork, things of that nature. So people like that matters are private if they're held in the trust. They don't get really advertised. It's faster and it's cost effective, meaning you're not paying a lot of different fees for people to go track down your property by the hour, figure out where it's going, and that can just cost a lot more than if you had everything in the trust and it goes there.
Is that what happens in probate?
That's
if
right.
You're not okay.
Yep. So the trust, when people talk about a trust, it can sometimes be intimidating. You're like, oh, I don't have enough money for a trust, or that's for really, really wealthy people, or whatever it may be. Well, really, it's for people that want a way to speed up that process when they're gone, that avoids the court system and keeps it in a costly way. The other piece of the trust is the trust never gets incapacitated. The trust never goes to hospice, and the trust never dies. So if you think about having that trust and you've got an account in the name of that trust, either at the bank or a brokerage account, and if someone goes to hospice, then those bills still need to get paid. Basically, you can get that basically hospice letter, and the trustee has the document. I'm the successor trustee. They take that to the financial institution, and they're off and running, paying the bills for your care. They're not having a situation where that's frozen or something of that nature, where they're waiting for other documents or things like that. So it could be a nice incapacity tool as well.
Yeah, and if you create a trust tomorrow, can you add assets to that ongoing, or do you have to rewrite it every time?
No,
Okay.
so you would go buy a house, you would title it in the name of that trust, or you'd go buy a car, you'd put it in the name of the trust. So the ideal is to have everything in the trust. And sometimes, let's say I have my Social Security going into my bank account, and I've got all these direct deposits, and they're taking my cable out, and if I go to the bank and I change it to the trust, they're going to change my account number and new checks. That's where you can add that beneficiary, and you can just put the trust as the beneficiary, right? So this is a concept where, think of that trust like, if you think of it like that shed, and everything's in the shed. So let's say that you forgot to put something in the shed. Well, there's a will for that. So you still have a will. If you have a trust, you still have a will. Sometimes they call that a pour-over will. So a pour-over will means that if I forgot to put it in the shed while I was alive, throw it in the shed after I'm gone. It tells the court in the probate that it's basically a couple pages that says, here's my will, see my trust, put it in the trust. So that's really a concept that a lot of people, that's when you're gone for end of life, to have that in place. While you're still living and you're making decisions, you need separate documents for that. Those are the powers of attorneys that we've talked a lot about already today. So medical, we've hit on that. Medical power of attorney is who's going to make that medical decision, talk with the doctors, do what you think you would have wanted done in that capacity. With that, a living will means your will to live. Think of it that way. So a living will is, what do I want extraordinary measures to extend my life if the probability is really low that it's not going to be extended, right? I just had a client, is a good friend of mine, that surprisingly passed away, and before that, though, for 2 days he was in that state, and the probability was really low, and the family decided there's no way. It was very clear, he had the documents, there's no way he wanted this prolonged, and they removed life support, and he passed. And so that's the living will. So sometimes when people say a will and a living will, you get them confused.
Sure.
What are those? But that's what the living will is it's basically a shorter document that says, here's my wishes. Do I want life extending measures, or do I not want that? And you initial that and you notarize it. And then finally, the power of attorney for financial is, who's going to, and this is not just financial, but sometimes a durable power of attorney. Who's the person who's going to walk my dog, pay the MUD bill, keep the lawn mowed if I need to, hire a landscaper, that kind of thing. That's the power of attorney that's taking care of the financials. Pick up your mail, sign a lease agreement, renew those kind of things. That's the power of attorney. So those are the core documents. When people say core estate planning documents, or if somebody asks you, I mean, it's not crazy to think like, what is an estate plan? Somebody says estate, what does that mean? That sounds like what really rich people have, and I don't even know what that is. Like where I grew up, it's like, what is an estate plan? An estate plan is that. It's having your wishes documented either through a will or trust with a pour-over will. It's having a financial and healthcare power of attorney and a living will all in place, and then taking that extra step to fund those items and put the titling in those accounts.
I mean, I view them all as assurances, or as best as we can, assurances that your wishes get carried out, right? Your wishes for your health care, your wishes for your assets, or what any of that looks like. So
Yep.
You had said some earlier, we were talking about a will. You have an executor of a will. And in an earlier question, we're talking about who do we trust? Who should we designate to do, what the role, what is an executor of a will? What is their duty, or what do they or don't they do, I guess is the way to put that.
Yeah, so the executor is going to be the person that carries out what the distribution pattern you had in place in the will is. Okay, so that person you don't have a trust necessarily. There's an executor of the will. They're going to go around and make notices, call people. They're going to have a copy of death certificate. They're going to make sure to say, okay, you had an account at this institution. What forms do they need to fill out to do that? They're going to fill out those forms, put them in place. They're going to work with a tax professional and possibly the attorney to make sure that before they distribute the assets out, that there's any debts or liabilities, or there's any items that need to be covered for taxes or held back for that kind of thing for a final tax return. They're essentially settling the estate. In that respect, a trust will have a trustee, and then when you're typically the trustee of your trust, but when you're gone, there's a successor trustee, and that successor trustee, similar to an executor, would be carrying out the terms of the trust, making those payments, date of death valuations on property, appraisals, things like that. If you have real estate or businesses, things of that to transition.
So you have a will, you're still not going to avoid the legal probate.
Right. If you have a will,
system.
just because you have a will, it's still going to go to a judge.
And I think
There's still going to be time.
there's a lot of misunderstanding with that is if I put it on paper, then I can avoid probate, but
Right.
you still have to have the courts
That's right.
work that document, right? But a trust, do you get to avoid the court system with a trust?
Yep. So the trust doesn't go through the probate process. So it's basically can be distributed when it's ready to be distributed.
Right. So like you said earlier, it's not about the amount or the size of the estate or the assets.
Right.
It's about streamlining and making things efficient and easy on those that you're leaving behind.
That's right. So you may save a little on cost to do the will, but then you're going to pay an attorney to represent court, to appoint the executor, and the time, and that there's some cost there too. So that analysis, if you pay a little bit more up front, you
Yep.
can, and you have a person that you trust to be that successor trustee to carry that out, it could be a cost savings too, depending on the state and all those variables, which
I think that's an
are all
important point
different.
that I think people often
Yeah.
they often overlook. So
And again, it's really important that if you put a beneficiary, so let's say you had a 401k or retirement account, you had an IRA, and you designate a beneficiary, that supersedes everything. So it supersedes, you might put your trust as the beneficiary, but if you put a person if you have your will, just because you have your will, if you designate a beneficiary for life insurance or for an IRA or any of that, that's where that money's going to go. And that would avoid any of the probate court as well.
good. Similar question to the medical power of attorney stuff. Are these documents that need to be filed with the state, or do we need to do anything in particular with,
Nope.
with
Those
estates
are
and
held.
wills?
Those are held with you and not filed.
They need to be. The will needs to be done, and it's filing the right term. But when it needs to be executed,
You'll need those original documents after your executor will need those original documents to show to take to the.
But there's no repository of documents that the
Right.
state has
No.
okay. We've touched on this, but these are documents that are going to change as you change and your situation changes. Can we update documents, or do we have to redo them?
So you can update documents. There's some terms out there that get thrown around, and every state's a little bit different. So some states You can update your will, and that's called a codicil. So that term codicil is a change to the will. If you have a trust, you may have heard of a trust as stated and amended. So you can amend your trust. So there's a certain article where you want to change somebody to take a different role or distribution pattern, or maybe you left a little bit to charity and you want to change that and add somebody else. That could be an amendment to the trust. Sometimes obviously you want to talk to an attorney about all this, because the attorney might recommend just restating it, having a new trust, depending on all the changes you want to make and what dynamics that change would create in other parts of the document. So that's where it's good to have a specialist, an attorney that's licensed to practice that with a lot of experience.
But we can change them.
Yep.
And we should change them.
Yeah.
Over time.
Yeah. So today, my 13-year-old is not a candidate to be my financial and healthcare power of attorney, but my hope is that when she's older, I'm going to change that, right?
Sure.
And that's a natural evolution of how that plays out.
And I've run into situations too where the situation has changed and that person's wishes have changed, and they didn't make the change in the documents. That's a tough place to be.
Really
right?
hard.
I mean, because the documents are what guide the rest of us when you're not here. And
That's right.
right. So I would echo. There's a life change. There's a financial change. There's a philosophical change. Redo the documents, update them. It's the best assurance that we all have of making sure we're treated and cared for in the way we want. So, great. What kind of documentation do my heirs need to obtain to handle my affairs at the end of life?
So what they'll want to have is all of the core estate planning documents that we've been referring to. A financial statement would be great. If you can have, what you don't want is everybody's in the house and they're looking, they find a checkbook and like, well, do they have the account there? Is that an old account? They call the bank says, well, you're not authorized. Well, they passed away. All these things can be abbreviated if you just keep really a current statement or a listing of just, inventory of assets and property and how things are titled. So copies of that are great. Any policies, those original policies are really helpful. There's ways around it if they're lost or destroyed, but essentially you want those policies in place, and really those core documents. So that's the best piece, is to have that. And then I would say any of the, a list of like what you have from a password perspective, but what bills are you paying or what's coming out? You're going to notify Social Security, or you're going to notify Netflix account, obviously is not going to be paid anymore, or things like that. So having a list of what's active out there and in place, and things that are important to you, making that list is not unheard of, just to put that in writing.
Yeah, and similarly, I've had situations where spouses have been left behind and don't know websites, certainly don't know passwords, maybe haven't picked up a checkbook in 30 or 40 years because we have the you've got distribution of household duties and it falls to somebody. Right. And so doing the things we're talking about, planning for it, is absolutely important, but helping those that are going to be left behind and carrying on these tasks, giving that information out ahead of time, right? Like let's work on paying bills. One person's done it, one person hasn't. There'll be a day, some Tuesday, where that duty is going to fall to the person who's not done it.
Right.
So we're talking through things like that, and those aren't things that people are thinking about when you get into the throes of an end-of-life situation. And we took care of big pieces, right? We got the living will, and we got our paperwork, and we got our trust, but how do we access some of the day-to-day stuff?
If you have capability to keep an emergency fund, that's general financial planning, but just some liquid available cash for that spouse to have, or for whoever's going to do that end-of-life planning, it's really, really good to have a basic emergency fund and list that out. And it's a lot of times one person will take the lead, and like you said, division of duties.
Sure.
It's really good to have a formalized time every year where you sit down together and say, hey, here's my passwords, here's my email, keep the email active, keep the login there, that kind of thing. If you use iCloud, or you use if you don't know those passwords and it's authenticating to a cell phone and you cancel the cell phone, that can be a cumbersome, stressful process. So just getting together and saying, here's where things are going, here's our budgeting process, here's where all the assets are there any other accounts we can't think of, or oh yeah, I had that oil interest from Western Kansas that I happen to still own from my great grandmother. It's like put that down while you're thinking of it, and have a consolidated place to go through it is really helpful. It's a really good gift of making things easy, so
Sure.
somebody can grieve when they want to grieve.
Yep.
And doing a lot of this, if you are faced with life-threatening or illness, it can be something that something else you're concentrating on, right? Like it's another piece that you're actually going in and you're able to check those. If you're a task person, I'm very much a task
Yep.
person. I have
Yep.
a list in the day and I move it to the next day or I complete it. It feels good to go through that while you have a day where you're having good health or you're competent. It's really good to do that when that's happening versus letting this kind of fall away
Yep.
and be in the lap of somebody else.
Yeah, and I would say it is a gift, right? All of the planning that we've been talking about, it's a gift that you can bestow upon your loved ones. And I'm not necessarily talking about assets, right?
Right.
From distribution of a trust, but a gift of taking that burden of thinking about all the details and the bits and pieces. And the unfortunate thing is that takes away from bereavement and grief and a natural process that we need to go through. So that's good. I might jump ahead here.
Yeah,
I don't know if we're
take
going to
the
ask this or
conversation.
not, but you talked about the timing of things and having some liquid, some cash that's liquid available for that spouse or whoever it is to. If you don't have plans, if you don't have a will, if you don't have a trust, your estate goes to probate. Is it 2 months? Is it 3 years? What does that look? What does that look like? I mean, now we're getting the court involved, and
Yeah.
that's not a speedy process.
So at a fast settlement process, you're in an 8 to 9 month period. At a post-COVID, you're closer to that year plus with probate. I've seen cases that are 6 years,
Wow.
from that. So if you have to like sell a house or settle different property or things like that, if you are waiting on a number of different factors, right? Sometimes you're waiting on the IRS to get back to you for evaluation or various things. So not having anything will delay it further, you know what I mean? And so having access to the funds that you're going to need in the interim, or making sure that, it could be as simple as keeping the lights on at the house till you get a chance to get everybody there to go through things or get it sold, that kind of thing. Having that fund or that slush fund there makes a lot of sense.
Because if you're in probate, nobody can access any part of the estate. Is that true?
Well, once you've gone through that, the executor has been appointed. They can do things, but they can't close the estate, right?
Okay.
So you can't necessarily. So you would have the
You have
ability
access to
yeah,
live and
right.
carry out day-to-day
Right.
business. Okay.
But if there was ambiguity and there wasn't certainty on who was getting what and what percentage, then you can't, right? That's going to be held up in that process. So makes a lot of sense to have, some assets, if they don't have a beneficiary on them, if you have the trust, some of those pieces to avoid the court system to the extent you can, it's very helpful.
Hey, so what if you have a will? You're still going to the court system.
Yep.
I assume that moves faster than if you have no documentation
If
in place.
if it's clear on who's doing the duties and writing that out, that's a definite plus.
And then a
for-
trust, you're not even in the court system at
Right.
all at that point.
Right.
So,
Yep.
okay, great. That's a great question. How does debt get handled? Debt that survives the person who owns the debt.
Yeah. So generally speaking, the executor or personal representative would notify the loan holder, who they passed away, and then they have in different states it's different things, but generally it's about 6 months where they can make a claim on the estate. But most people are using the collateral, the asset, to either sell it and pay off the loan or that kind of thing. So that's how debt's usually handled. The debt would be subject to the assets of the estate.
So
in
debt
that
doesn't
situation.
disappear.
No,
It's
debt
tied
doesn't
to the
go with you.
estate,
Right.
right?
Right.
Does in a situation where there's a spouse, does that person inherit that debt? I mean, the estate does, but that person individually is not responsible for the debt. Or am I misspeaking?
Well, if they're typically a co-owner or a joint, or they're in the trust and they're a trustee, then they would be carrying that debt on as long as it's theirs. If they're not a cosigner or anything like that, you're not necessarily inheriting the debt, but the estate of that person's assets would be
He's
there to
responsible
offset.
for it. Okay.
Yeah, for that. Yeah.
This is a tough question in the sense that it'll be lengthy potentially, but what are the keys to minimizing taxes on my estate?
So we talked a little bit about inheritance tax and that kind of thing, but if you have a financial plan, right now there's exemptions at the federal level for estate taxes. So today an individual can leave $12 million of their net worth, property, real estate, investments, that kind of thing, free of federal estate taxes. A married couple can leave $24 million. So that's a big number. If there's assets over that, the tax rate's 40%. So there's different things people can do at the state level. They're compared to that tax rate, it's a lot lower. The issue that's coming up and what's being debated is the Tax Reform Act that the Trump administration passed is sunsetting in 2025. So those numbers will be cut in half. So instead of 12 million, it goes to 6. So what a lot of people can plan on is if you aren't in the risk of getting to those numbers, then you really don't have a big concern about estate taxes. What you're trying to do is button it up so it's seamless, have beneficiaries, get all that in place. If you have a financial plan and you're projecting growth numbers, you may look out and say, wow, if I'm 70, I'm going to get close, or some of these numbers are happening. So it might make sense to look at doing some of that gifting now. So some people will set up, even an irrevocable trust where you're gifting money for the benefit of your children or grandchildren, and you're gifting money over there to try to dampen that growth to keep under that limit. Mm-hmm. There's other strategies, of course, depending on the case, but generally speaking, estate taxes are going to really apply to those people at those levels for the most part. By having things titled correctly and getting beneficiaries in place, you're going to avoid a lot of.
So if you're gifting yearly, right? Because you're able to do it. It's a dollar amount per year. Is that right?
So they allow you $16,000 a year
per person, 2 person.
Yep.
Right.
Yep. So I could give $16,000. You could give $16,000 to anybody.
Okay.
Yep.
Do those dollars start to come off of the exemption? Does that count against your exemption?
So they don't. That's the exempt amount per year. Anything over that would come off that.
Oh, okay.
That's that
okay.
12 million per person.
So you can gift up to the max every year, chip away at the bigger piece that's
Right.
subject to estate taxes.
Yep.
It's hard to figure that, right? I mean, that's where it takes a real plan to be put in place. And
yeah, it's really good to have a financial plan to say what would happen if I incur that major health issue and some of those expenses, and then what if I went into assisted living? What if I had these expenses? There's ways that you can develop a plan to have a strategy around, one, what investments should I be invested in to help meet these near-term and long-term needs to try to keep up with some of those risks, healthcare costs, longevity, that piece. But then if you have that surplus in place, or you have some pretty good certainty around that, then gifting can apply. More advanced strategies come in once your financial independence is secured.
Sure.
But that's really important to think about all those different outcomes.
And a trust does not give you any tax sheltering opportunities.
Right. The
You're
trust
still subjected to.
Revocable trust is you, essentially, in terms of a tax scenario. Yeah.
The shed. They're coming after the shed.
The shed, right.
Wherever
exactly.
It's at. That's right.
Exactly, the shed. That's right.
Yeah, I think we've covered a lot of this, but how do I best prepare for finances for end of life, right? We're talking bank accounts, stocks, life insurance policies, mortgages, deeds. I think what I'm picking up on is the most straightforward and best approach is to put them inside of a trust.
Maybe, it's at least have a list and organize it, and then make sure beneficiaries are who you want in place. You know what I mean? And a trust could be a good part of that, depending on your situation and
Sure.
the attorney, but really being intentional about what you have and where it's going and listing that out.
Well, so and I don't know how widespread of or how applicable this is to lots of us, but how about maybe we could talk briefly about distribution of business assets, like if we're talking about owning, whether it's a PC or an LLC or what that looks like upon passing.
Yep. So usually a business is going to have, depending on the structure, it's going to have some kind of operating agreement, right? If it's a partnership, it's going to be operating agreement. If it's an S corp, you're going to own the shares, and those can be titled or assigned to you individually, or they can be held in the revocable trust. Those are good assets. So those can distribute. What you want to have in place there is, with businesses, it's really about defining what would happen if you were disabled. If one person's doing a lot of the work on business development or sales, the other one's more operational.
Sure.
Who's going to fill that role, and maybe thinking about what that succession plan's like. And then it's really the conversation about valuation. How do we value it if I'm gone? Are we getting 2 appraisals? Do we sell all of the equipment? Does someone want to own it? It comes into play even with like farming, and some people will distribute. There's difference between what's fair and what's equal, right?
Sure.
And so if somebody's stayed back and worked in a business, one of the kids worked there for 3 decades, and the business has this worth, and all of a sudden the other kids think they need third, or whatever it may be, that may not be the equitable piece, right? So getting ahead of that and thinking about, okay, how do we equalize things in what we feel is fair?
Sure.
There's no right or wrong answer for that, but technically it's really just getting those assets assigned, having a succession plan, knowing how all the partners of the business are comfortable with it being valued.
In the absence of a succession plan, does the business end up in the court system as well?
The business would go, if it's in the trust, it would go to the beneficiary, and
Sure.
then they would have to settle that business.
If it's outside of the
on.
court, there is no trust, or it's outside of the trust.
Yeah, or if it's in their name, the executor, the business would be in the will to whoever, and then they would carry on that business, or the court decides. Yeah.
Good. So how can we make financial preparations at the lowest cost, right? Do we need a lawyer for all of the things that we're talking about? Are there pieces, again, that can we do some of this at home in the living room online? What does that look like?
Yeah. So, one of the pieces is you can go in and make sure all of your property has beneficiaries, even to your house, and have that in place. So from a basics perspective, if you didn't have the means or really time to go through that, if you can't get a document drafted for 3 or 4 months or
Sure.
whatever, go in and have beneficiaries added and make sure that's in place. The powers of attorney, the most cost effective is going to be just to go to the attorney and have them set it up. In the long run, it's going to be likely accurate. You're going to have that in place, and it's refreshed. And then, you do have there are some online services available where you can go in and do a template. You probably find that, which would be lower cost, but without having an attorney look at it, who knows the impacts of
Sure.
the various
Right.
sections.
Right.
that
I mean,
can
I would
happen.
say among many, but one of the obvious benefits that I see is that there's a whole bunch of unknown unknowns, right?
Yep.
Unless you're doing it every day, and so you guys probably have a very strategic way of going through that thought process. And do we have everything, crossed and dotted and everything that
Yeah.
we need?
So attorneys that do it, they have a process for a reason. They know, they do a lot of them. They know how it works, what doesn't.
Yep.
And,
Yep.
and it's important to have that specialty. One piece while we're talking about it is, you think about what works in theory and then what works when the rubber hits the road.
Yep.
We've talked a lot about that, like in real life, what happens.
Right.
And I think these are good avenues for that, right? Bold and Brave is a perfect spot to talk about, okay, well, tell me when the rubber hits the road. So, like, some things to think about is if you have a life-threatening illness and you say, well, I have a power of attorney, but it's dated in 2013, pretty soon that's going to be a 10-year-old document. While that is legally a good document and it still has everybody you want to do the roles that they want to do and all that's in place, the financial institution, bank, brokerage house, wherever, may not be comfortable releasing thousands of dollars or giving access to that
That's a good
person
point.
with the fear that there may be a newer document floating around.
Sure.
So if you have life-threatening illness or things like that, I would say that you would want to ramp up how often you update it, and maybe you can talk to the attorney about, hey, I'm not going to change anything. I just want to make sure it's refreshed every so often, or renewed or notarized. So there's a copy there that's at least within a year, where they could say, hey, okay, this has been, a pretty recent document.
Because those institutions can set their own policies, right?
That's
right.
right.
You walk into the bank, they don't have to necessarily accept a 12-year-old.
Yeah, I mean, they eventually will have to,
right?
When you get the judge involved.
Right, but on
it's
Tuesday
like
when you walk in and
quick.
talk to
we're in the middle of building a house, and there's a draw from the builder, and somebody passes away or gets incapacitated. You're dealing with all these documents. It's a stressful time. Life happens.
Sure, absolutely.
So
what happens if I need medical care, hospice care, end-of-life care, and there is no money available? Do you have? I'll contribute some things from the medical piece. Is there anything from your world that is worth discussing with that regard?
Being in investments and financial, that's not a real common piece that we see. So I don't have a good research for that one.
I would say from the hospice perspective, let me first speak to Medicare. Medicare kind of defines what we do, and so whether you're Blue Cross or not, the world looks fairly similar. Hospice, from a Medicare standpoint, hospice is 100% covered. We're all entitled to it if we're of Medicare age. The only cost that typically comes with hospice is some medications that are unrelated to the reason that you're on hospice for. Those will fall to the same payer that they were before you got sick. The one financial piece that is a bit of a shock to people is if somebody were in a position of needing 24-hour care and cannot achieve that at home. So we're talking about moving to a nursing home or something like that. Medicare does not pay room and board. And so that's the real financial piece, I think, to consider. Some of those places, they're $7,000 or $8,000 a month. And there's lots of us that don't have that put away for more than a month or two. So it is a consideration. It's not an unknown for those of us in the hospice world. So we work through that. The real assurance is the medical care will be there. You will be well cared for. If we're talking real briefly about hospice that's not Medicare, each of those insurance policies is written a little bit differently. I've only come across 2 in the last 15 years that had no hospice benefit. Almost every other one has a hospice benefit. Sometimes they're defined by an absolute number of days. Most of the time they're not. I don't believe I've ever known anybody to have a financial component to that they're responsible for outside of typical copays and deductions. But when we're talking Medicare, the finance piece from a healthcare perspective really should be kind of taken off the table. Hospice will be there to care for you. Let's talk a little bit about another potentially financial stressor or burden, and that's funeral arrangements.
Yeah.
How do we make those plans? Most importantly, how would we make those plans if there are no funds available? What does that look like for people?
Yeah. So it's tough. I mean, a lot of people, you're trying to plan ahead for end-of-life planning can be everything from, thinking about your obituary to, all the different pieces that you want to have in place. At that time, that's one of the benefits of, having a diagnosis where out front as you can plan for some of those things.
Sure.
So a lot of folks will go ahead and prepay or pre-plan for arrangements. What it does when you at least let everybody know or tell people is it takes the burden off. So that's one piece. So if you don't have the money, typically the most cost-effective way is cremation, and that is typically ranges from $300 to $700 kind of range, just to give you an idea. Can be $1,100, somewhere in that range. If you didn't have the funds, typically what would happen is there would be a crematory that would take that place, and there would be, if there wasn't any plans for burial at all, it would just move to more of a common, area to store or to bury those remains, if you would. I think sometimes you have the option, if they do the cremation, to pay a fee to keep it, for heirs, so they could pay that fee. So if you really didn't have any money at all to cover that, there's a way that the normal process that's commonplace where they take care of that. Ideally, you would, save up or have some funds to go ahead and prepay that, so it's taken care of. Or if you can't, tell your heirs or the people around that care about you it's okay. You know what I mean? To let them know, right? Because part of that is the unknown, and the heirs are going to have to try to figure it out.
Sure.
Figure out how to come up with the funds, that kind of thing, and that can be more of a burden than just the freedom of knowing what you desire.
Yeah, and it is a situation that in my world we do run into with some frequency. So the state does have a process, right? There's the I've just blanked on the name. Is it the Arbor Society?
Oh, yeah.
But there is a state process for people that have no funds to pursue cremation. I think that there's still some, like you said, of a few dollars that, but there is a process in place. The state has a lot of interest in making sure that that's done safely and properly. Yes, there is a process for that. I think with a lot of the stuff we've been talking about, unfortunately, there aren't a lot of good solutions for people that don't have a lot of funds accessible for this kind of stuff. But so how do you pass on custody of a minor child if I'm a single parent? We talked a little bit about guardianship, and that does that fall into the will? Is that the document that one needs to prepare?
That's right.
Is that the only document that's
the trust could also indicate, if they did a trust or a will could indicate guardianship, and it doesn't have to be a family member. It can be a trusted friend. So if you don't have support, or you don't really have, everybody to rely on, you can name any, it doesn't have to be a relative, it can be a trusted friend or somebody like that. But it would be named in the will, in terms of who would be the guardian to take care of minor children.
Good. There's a question here about resources and benefits available to my children or my child at the end of life or upon my passing as a parent. Certainly add, if you have something to add to that, please do. The bulk of that, I think I'm going to shelve. We have a talk coming down the road where we have a social worker who will join us, and we're going to talk about bereavement and grief and some of those resources.
Perfect.
Are there financial benefits, say from Social Security? Is there a death benefit? If there's no life insurance, if it's all we're talking about state and federal dollars, what does that look like for people?
Well, Social Security would be the main one. Where if the person had paid into Social Security, there'd be a benefit, assuming the children were under age of 18. In that regard. So there are resources there, and that would be a tip for them to make sure to contact Social Security Administration to see what those benefits are, upon passing. You can even call ahead, if you had an illness where you're like, hey, I want to make sure this is covered. What do they need to do? What's the number? How do we set the appointment? Just getting those ducks in a row. But Social Security Administration would be a good avenue.
Sure. And there is a passing of Social Security benefits from spouse to the surviving spouse. Is that right?
There's a widow benefit. Yeah.
That's far more complicated than I would ever pretend to understand. But it does exist, and it's something. That's another piece to think about.
Right. That's right. Yeah.
Is there anything from that? And if it's not your world, that's okay. But is there anything that we would have to think about to prepare from a Social Security standpoint, or is that an automatic process? You have to file? Does somebody have to file paperwork? Or?
There would be paperwork, but they would walk you through that, whatever's the needed paperwork at that time.
Okay.
You just make the appointment. And, yeah.
Great. I think we've covered lots of this because these questions are talking about what do I do if I have no support system. We talked about the financial piece to that. We talked about you can be a friend, family, colleague, somebody that's willing to play a role that needs to be played at that point. So let me open it up. Are there any questions that we have from the audience that's related to kind of this section on financial interests? Is it true that you should not list minor children as beneficiaries?
It's a great question. It's typically not ideal to list minor children as beneficiaries. So that does not mean in a will. So just to clarify, so let's say you have a retirement account and I want to leave them to my kids and they're minors. That what you think you're indicating through the beneficiary portal will ultimately still end up through probate. So it's still going to actually have
It doesn't save any.
that,
It's not
right,
saving you anything.
right, and that account would then go through the same mechanism as the will would provide, but it would basically be in a position where there'd be more conservatorship till their age of majority. So it's usually not ideal to list the minor as a beneficiary. If you can basically, and the other mistake some people think about is, well, I want it to go to the kids, but I'll leave it to my sister because I know she'll get it to them. Well, sister's going to have all the tax burden, right, on that retirement account. So what's ideal sometimes is if you have that trust, you can leave the trust as a beneficiary, which would carry that out, or you can just leave it by your estate, which would go to the will, instead of having them identified as beneficiaries on the account.
What if say we're talking about term life insurance, right? Who
Yep.
your beneficiary really, it is going to go to the kids, right?
Yeah.
Or
Yeah.
so is that okay to list a beneficiary on that in that situation?
It's still going to end up going through. They'll have a guardian to shepherd those funds, but
Okay.
yeah, it would still get to the right place.
Okay.
Yeah. Yep.
So not great practice, but
But if your back's against the wall,
if that's what you got, it's where you're at,
right.
and it'll get figured out. But I mean,
Yeah.
the way I look at it is even if it's not all that could have been done, it gives your wishes are
documented
are
in the
documented
will
and
and on the
expressed,
beneficiary.
and,
That's right. Yeah.
great. Good. I think if there aren't any other questions, we're going to wrap it up. We've had a fantastic conversation. Ryan, thanks again for
Thank you.
being a part of this.
Great to be here.
It's been great. Lots of actionable items. We are in the process of building out a resource library to acquire some useful tools that have been applicable from the prior talks and as well as tonight. We'll have that up and running by the time our next conversation happens. We're going to take a month off. We'll be back in June towards the end of the month, and we'll speak more to the resource library. I think anything you have that you find valuable for us to include as easy access for people, we'll throw it in there. It'll
Sure.
be great. So thank you again for joining us. You brought a lot to the table. We all appreciate it, and we will see you in a few months.